On behalf of Jones Day, we'd like to welcome you to a briefing on the EU-U.S. Privacy Shield. Our program today is being presented as a webinar. This program is scheduled to run from 12 p.m. to 1 p.m. Eastern Time. If you're having difficulty hearing me, please check to make sure that you have the volume on your computer turned up all the way. If you have any other technical difficulties, contact the Beacon Live Help Desk at 1-877-297-2901. Also, if you have not already downloaded a copy of the CLE Credit Information Sheet, you can do so from the Handouts tab on the left. This presentation has been approved for CLE credit for attendees. The CLE Credit Information Sheet provides you with information regarding the available credit. Applications for a CLE credit in other states will be made as needed. Please keep in mind that CLE credit is not available when viewing the on-demand version of the webinar. There are several important steps that you must take to demonstrate that you are actively participating. First, each participant must have registered individually for the webinar in order for your time of attendance to be recorded. If you are not individually registered for this webinar, please do so by immediately contacting William Slate at wsleight@jonesday.com. Second, at various points during the webinar, a box will pop up on your screen asking you to confirm that you are viewing the webinar. You have up to a minute to confirm participation. If you do not confirm each time the box appears, you will be denied CLE credit. Third, you must be logged in for the entire presentation or segment. Otherwise, CLE credit will be denied for that segment. Within 24 hours, you will receive a link to generate your CLE certificate. If you do not receive the email, please contact the Beacon Live Help Desk or email cesupport@beaconlive.com. It is mandatory to enter your bar number. If you cannot locate your bar numbers, please contact the Beacon Live Help Desk for assistance. You will be in a listen-only mode throughout the presentation. If at any time you have a question, you may submit them through the chat window located at the lower left corner of your screen. We will attempt to answer those questions at the end of the webinar. With that housekeeping out of the way, I would like to turn it over to Jennifer Everett, who will begin the live presentation. Thank you.
Thank you, Monica. The long-awaited Privacy Shield has finally been approved by the European Commission, now paving the way for U.S. companies to transfer personal data to the United States. The adoption of this new framework really ends months of uncertainty following the invalidation of Safe Harbor back in October of 2015. Now, companies have to consider whether certifying compliance with the Privacy Shield is going to be the best option for their business. Good afternoon or good morning. My name is Jennifer Everett. I'm an attorney in the Washington, D.C. office of Jones Day in our Cybersecurity, Privacy, and Data Practice Group. And thank you for joining us for this one-hour seminar on understanding the operational impacts of the Privacy Shield to your business. I'm joined today here by four of my colleagues to talk about this very interesting topic. First is Dr. Indina Vandemar, who is a partner in our Munich office. She coordinates Jones Day's privacy and cybersecurity practice for the EU. Jonathan Little is a partner in our London office. His practice focuses on technology, data protection, cybersecurity, and other high-value commercial products. Dr. Jorg Ladik is an attorney in our Brussels office. He leads the cybersecurity, privacy, and data protection practice in Brussels and advises clients on a wide range of practices, including compliance with international transfers. And on the U.S. side, I'm joined here by Todd McClinick, who is a partner in the Atlanta office. He counsels clients also on a wide range of data privacy issues. Now, just before we get started, as a quick administrative or logistic matter, the presentation today is it should not be considered or construed as legal advice on any individual matter or circumstance. At the end of the presentation today, there will be a slide that provides our contact information. So please, we encourage you to reach out to us if you have any questions or comments with respect to the presentation today or how the Privacy Shield impacts your business. All right, we have a lot to cover under our agenda. We'll start today by first giving a brief overview of the Privacy Shield, a little bit of history to understand for all the listeners how we got here. We'll then discuss the next procedural steps that companies can expect to be implemented now that the Privacy Shield is in place, and then give an overview or understanding of the Privacy Shield framework, and then do a dive into the operational impacts and really key considerations that your company should take into account when determining whether the Privacy Shield is right for your business in comparison to other data transfer mechanisms. We'll end the call today by talking about the self-certification process and then addressing some of your questions that you may have posed during the webinar. And with that, Dina, I'd like to turn it over to you. Can you give us a brief history of the Privacy Shield and how we got here today?
Many thanks, Jennifer. Before I come to the history of the Privacy Shield, let me please take a step back and look at the very basic question of what is the Privacy Shield actually. To answer this question, I think one would need to take a look at the European Data Protection Directive. The directive is actually the relevant legal framework and the basis for all the national EU data protection laws. And the directive states that personal data can only be transferred to countries outside of the EU and the EEA, the European Economic Area, when an adequate level of protection is guaranteed, unless certain derogations like, for example, consent of the data subjects apply. The Privacy Shield, like its predecessor program, the Safe Harbor, is actually a mechanism to ensure, to guarantee such an adequate level of protection on part of the data recipient. There are alternative instruments and mechanisms available, like, for example, EU standard contractual clauses, short form SCCs, or the binding corporate rules, short form BCRs. However, other than SCCs or BCRs, the Privacy Shield is only available, and I think this is important, with respect to data transfers from the EU to the US. Coming now to the history of the Privacy Shield, in a way it starts already with all the concerns and discussions surrounding its predecessor, the Safe Harbor. These concerns, as many will know among the audience, resulted finally in the invalidation of the Safe Harbor by the European Court of Justice in October of last year. Main reasons for the invalidation stated by the court were that the US government's ability to access transferred EU personal data was seen as not sufficiently limited in the Safe Harbor decision itself. And another important reason for the invalidation stated by the court was the perceived lack of judicial means of redress for EU data subjects. The invalidation of the Safe Harbor then put a lot of pressure, obviously, on the US and the EU side to come up with a transfer mechanism replacing Safe Harbor that would at the same time address the shortcomings noted by the European Court of Justice. After months of negotiations, in February of this year, the new so-called Privacy Shield framework was released to replace Safe Harbor. It became immediately the subject of intense review and scrutiny by various EU institutions and bodies, including the Article 29 Working Party, which is a body comprising of all the national data protection authorities across the EU. While all of them welcomed the Privacy Shield, at least as a positive step in the right direction, they nonetheless identified areas of improvement. For example, they required additional assurances from the US government that its intelligence agencies would not engage in mass collection, i.e. bulk collection of EU personal data. Those concerns resulted in continued negotiations between the EU Commission and the US early this summer to revise the original text of the Privacy Shield in order to address the concerns stated. Finally, on July 12, the EU and the US officials released the official text, the official final text of the Privacy Shield. The Article 29 Working Party reviewed again the then final version of the Privacy Shield, and in a statement of Tuesday last week, the Working Party gave the green light with some limitations. And those limitations concern not only commercial aspects, like, for example, that remains somewhat unclear how the Privacy Shield principles shall apply to data processors. The Article 29 Working Party also remains concerned with regard to the access taken by U.S. public authorities to data transferred under the Privacy Shield. So I think the important takeaway is from this statement that while the Article 29 Working Party still has lingering concerns, it did not request immediate action to be taken. Instead, it will wait until the first joint annual review date in summer 2017 to take another look at the arrangement. So in its statement of last week, the Working Party actually referred to this first joint annual review as a key moment for the robustness and efficiency of the Privacy Shield. Todd, could you continue?
Absolutely. Thank you, Dina. That was fantastic. Next, Jonathan and I are going to talk about next steps. Now that we know kind of the history that Dina has shared with us, what do we expect to see from both sides, the European perspective and the United States perspective? Jonathan Little is going to start us off talking about the European perspective.
Thanks, Todd. Well, from an EU perspective, we now have the Shield available as a way that you can meet the adequacy requirements under EU data protection law. And that's very welcome news. And importantly, the Shield is a way you can justify a systematic transfer of data. So it can be used to protect a data flow, not just specific data. It's not dependent on a specific context, and you don't have to have specific consents. So all of that is very welcome. And it gives automatic protection. So there is no longer any need to consider the adequacy of protection if you're within the Shield. Another consequence from the EU perspective is clearly those receiving EU personal data are going to be subject to stronger safeguards in the US than in the past. And there's going to be clear limitations and, to some extent, safeguards about US governmental access to that data. And finally, the EU authorities up to now have been in the mode of critically evaluating the proposal, and as Dina has said, they've made certain reservations or comments of things they'll be looking out for. But going forward, we'll move to perhaps a stage of implementation of providing materials for people, for providing guidance, and perhaps from a US side, even the start of some enforcement. Todd.
Thank you, Jonathan. And of course, from the U.S. side, the DOC and the Privacy Shield is open for business starting yesterday, August 1st. It's important to note that companies are incented to want to move rapidly towards certification with the Privacy Shield, because if you certify between August 1st and September 30th, you then have a 9-month window within which to get all your onward transfers in compliance with the Privacy Shield. And we'll talk more about what that means a little bit later on this morning. It's informative to note, according to the Safe Harbors website, and I do mean Safe Harbors website, that you can no longer certify to this now dead program after October 31st, which really doesn't help us much at all. Finally, just a couple other notes from an administrative perspective. We are currently in the development and fleshing out the Privacy Shield from a framework perspective in the United States. The Privacy Shield Ombudsman is in effect and being developed, and of course arbitration mechanisms are being developed and arbitrators are being selected. So the United States is very much moving forward, and the Privacy Shield is open for business. Now, Jorg, why don't you talk to us a little bit more about really understanding the Privacy Shield, what's behind it, what makes it up. Give us the essence of what is the Privacy Shield.
Sure, thanks, Todd. The Privacy Shield is actually a voluntary framework. It's a self-certification mechanism similar to what Safe Harbor was. So companies based in the United States must commit to a long list of privacy principles. There are 7 core principles, and these principles are then supplemented by another 16 principles. I would like to talk a bit about these 7 core principles to you now and outline a bit what they are in terms of content. The first main principle is notice, where basically companies have to inform individuals whose data is concerned in context of the transfers about 13 specific elements. We counted them regarding the data processing activities. Quite interesting. Here the list gets very long. And the background obviously is that companies should be very transparent in terms of what they do with the data they receive. Choice is another important principle, to provide individuals with choice on the use and disclosure of data. Accountability is a third principle for onward transfers. That becomes a lot of attention these days because, as you may know, transfers don't stop. When they get to the U.S., there's Onward transfers, there's contracts in place, usually between additional service providers, other companies, data recipients. So here, there's a strong principle in the SHIELD framework to include specific provisions to flow down obligations, actually, between different companies involved in a chain of data flow. Security, fourth principle. As usual, there are a number of requirements here. Security becomes very important these days, so companies should pay attention to that. Then we have another three principles: data integrity and purpose limitation. Purpose limitation, this is a main focus by the authorities in Europe these days to make sure data is only really collected for the purpose for which they want to be used for. Access, this is more the perspective of individuals that they have a right to have access to the information and to can execute also rights to correct, amend, or even delete data under certain circumstances. And the final principle, recourse, enforcement, liability, is important again from a governance perspective. Receiving companies have to implement mechanisms basically to assure compliance with the SHIELD, including a system, a mechanism in terms of complaints. So to sum up, there are 7 core principles. There's many more principles behind that we can share information later on if you're interested. And organizations have to publicly declare compliance with the DOC and then recertify annually, as was mentioned before. So back to you, Todd.
Sure, thank you so very much. Jonathan, what Jorg just went through sounds an awful lot like the safe harbor we used to have. What's different? What's the difference between safe harbor and Privacy Shield?
Well, I think the first point is, as I think you were hinting, this is an evolution. So if you take a close look at the Privacy Shield, you can see the DNA of the safe harbor running through it. So perhaps the similarities are going to be greater than the differences. The first point is it's a self-certification regime as it used to be. So people sign up to a set of principles and that is the process. The second similarity is it is still managed by the Department of Commerce and the Federal Trade Commission. So we have the same regulatory framework. And then thirdly, there'll be the same cycle that if you've been safe harbor compliant in the past, you'll be familiar with. You have an annual requirement to certify that you remain compliant. So those are the similarities, but under the surface, some things have changed. And the key changes are, firstly, the requirement to give notice to data subjects has been strengthened in significant areas. So your privacy policies and the other information that you provide will need a review. Under the old regime, it could be done at a relatively high level. Under the new regime, there's 13 areas that you have to give specific information on. So this will definitely require attention. The second significant change is where data is transferred to a third party. And now there is a requirement to have a written contract with the third party where you pass on the obligations of the Privacy Shield, and you have to require information back if the recipient cannot abide by them going forward. And that you shouldn't underestimate the logistical challenge of putting that in place. There's increased liability for actions of processors, and there is a wider range and a more effective system of recourse for EU citizens who feel their data has been misused. There's going to be regular and more rigorous monitoring of compliance, and you can expect regulatory oversight and the likelihood of intervention and enforcement to increase. One of the sensitive points for the European authorities was data retention, and that's been clarified so you can only retain data for the purpose, the time necessary for the original purpose, or as authorized. And there is a commitment by the US authorities not to use this to carry out mass indiscriminate interception and monitoring of data. And finally, there'll be an annual status check between the different authorities to evaluate how this is all working in practice.
Thank you, Jonathan. That was very helpful. Well, we've talked a little bit about what the Privacy Shield is. Let's begin the next stage of this discussion talking about, can you use Privacy Shield? And first, there's a bit of a jurisdictional question. and that is, are you under the jurisdiction of the DOT or FTC currently? As it's set up, only entities that are under the jurisdiction of these two particular entities can use Privacy Shield. So if, for example, you're in the telecom sector, if you're a meat packer, which I'm sure is a lot of you in attendance today, or if you're in the business, if you're most depository institutions and a number of other industries, if you're any of those, you are not under the DOT or the FTC. At least as of today, you cannot use Privacy Shield. We are expecting some movement in the near future. We think some of those gaps will be closed, but as it stands today, if you're not under the direct purview of the DOT or FTC, you cannot use Privacy Shield. We're expecting some state AGs to also be in the mix and mobilizing to allow for their regulation of this and therefore some oversight by them, which would further expand the scope of companies that can use Privacy Shield. Another important kind of prerequisite note is that it only governs data transfers directly from the EU to the United States. So if you have a roundabout way of transferring data from the EU to the United States, it goes through India or Brazil or wherever else, that will not be subject to the Privacy Shield. It has to be a direct data transfer. And just as a last note before we move on, and we'll talk a lot more about this later in the morning, but we are anticipating that companies who are currently under the safe harbor will find it easier to move towards Privacy Shield. So with that said, let's turn to Jennifer, who's going to talk to us a little bit about privacy statements and what is the impact of the Privacy Shield on business operations and privacy practices generally.
Thanks, Todd. As Jorg had mentioned and Jonathan mentioned from the prior slides, companies that are going to be certifying compliance under the Privacy Shield should realize that the privacy statements that are required are going to have to be far more detailed than what was previously required under Safe Harbor. Now, for those of you in the audience who either were or are Safe Harbor certified, you may recall that with your privacy statements under that prior framework, you generally just had to inform individuals about the purpose for which the data was collected and how it was used, give them contact information for inquiries or complaints, and among other things, inform them of the third parties to which you disclose the information. You could, under Safe Harbor, as a general matter, comply with this obligation by providing general information at a high level. Now, just as Jonathan had mentioned earlier, under the Privacy Shield, your privacy statements are really going to have to be revamped in order to incorporate the 13 specific points that are required under the notice principle. Among other things, and we won't go through all 13, but just to highlight a few, you're going to have to, in your privacy statement, identify your participation in the Privacy Shield, and provide a hyperlink to the Privacy Shield list, as well as to the Department of Commerce's website. You're going to have to publicly commit to comply with the principles for all personal information that you receive, provide a contact information for your inquiries and complaints just as you did under Safe Harbor, but also really identify the categories of third parties and give individuals an overview of their right to access the data, among other things. Now, one thing I also want to point out here is that some of you on the call may have tailored your privacy statements to meet California's Online Privacy Protection Act. That CALPA applies to any person or company in the United States whose websites collect PII from California consumers. CALPA requires specific provisions in it for privacy policies to comply with that law. However, meeting the provisions of CALPA will not be sufficient to meet the 13 specific enumerated points that have to be incorporated in your privacy statements to comply with the Privacy Shield. So the takeaway here is that, before certifying compliance with the Privacy Shield, to really take a close look and examine your privacy statements to make sure that you've incorporated all 13 points, and then, as we'll discuss later on, that you can actually comply with those provisions. Todd?
Jennifer, thank you. Now let's talk about another operational impact, something that both Jorg and Jonathan have alluded to already this morning, and that is with Onward transfers. So the situation is you have transferred your data over from Europe to a Privacy Shield organization, and then that organization wants to further transfer the data either to someone else who is going to be a data controller or to someone else who is their agent or processor. Now, as Jonathan was mentioning, there are a lot more strict requirements that are being imposed under Privacy Shield than what we previously saw under Safe Harbor. And what we're seeing in many respects are some very striking similarities to what is required both of controllers and your processors. In terms of the similarities, both require a written contract. And in both instances, the use or the processing of data by either of these types of entities, controllers or processors, it has to be done, and this is the language, for limited and specified purposes. So you have to be very clear on the purposes that the data is being used for both of these types of third parties. There is also an obligation to provide the same level of protection as is required under the Privacy Shield principles. Now, on the processors, and Jonathan was also making a reference to this earlier, there is an obligation on behalf of Privacy Shield organizations to be responsible and take appropriate steps to ensure that the processing is effectively done by the processor. And they are responsible for the acts of their processors, and they have to take steps to remedy any non-compliance. Now, on the controller side, the third-party controller must notify the third-party Shield organization if it cannot provide the same level of protection, and it has to take steps to remedy any kind of non-compliance which might be identified. Now, it's interesting to note, Jennifer went through some of this, but there are obligations with respect to the compliance with notice and choice principles. Now, when it comes to third-party agents and processors, generally true, but the opt-out is not there. A data subject cannot opt out of the processing by the third-party agent. Now, there are exceptions for sensitive data, which are opt-in, but then there are exceptions to exceptions when you're talking about HR or other types of data. So you really have to ferret this out and really further explore the nature of your data flows, what's being processed, how it's being processed, and we'll talk a little bit more about that. Next, let's go back to Undina to talk about recourse mechanisms.
Thank you, Todd. As mentioned earlier, one of the concerns that led to the invalidation of the safe harbor was actually the lack of judicial means of redress afforded to EU data subjects in the U.S. And to address specifically this concern, the Privacy Shield now provides really for a variety of different recourse mechanisms available to data subjects. There is no order of priority in which such recourse mechanisms should apply, except for Privacy Shield panel arbitration, which is meant to be an option of last resort. So what are the available recourse mechanisms? First, a data subject can complain to the Privacy Shield company itself, and the company then must respond within 45 days of receipt of this complaint, including an assessment of the merits of the complaint and information on how the company will rectify the problem. Secondly, the company certifying under Privacy Shield must designate an independent recourse mechanism. It can either designate an independent dispute resolution body or alternatively submit to the oversight of EU data protection authorities. Similar to the situation under Safe Harbor, a company actually must submit to DPA oversight if it processes HR data for purposes of employment. It's important to note that even if companies are not under DPA oversight, that individuals can still bring complaints to their national DPAs. And such complaints can in turn be channeled to the Department of Commerce or the Federal Trade Commission. Both the DOC and the FTC will establish contact points for such referrals. As mentioned, an option of last resort, so when all other redress options failed, is the Privacy Shield panel. A data subject has the right to invoke arbitration with the Privacy Shield panel under these circumstances. The Privacy Shield panel is an arbitration mechanism made up of 3 neutral arbitrators. Its decisions are binding and enforceable in U.S. courts. Only the data subject can invoke arbitration through the panel, not the Privacy Shield company. What is new under the Privacy Shield is that with regard to access to EU data for national security purposes, there is for the first time a special instrument existing, the ombudsperson mechanism. The Privacy Shield ombudsperson is going to be a senior official within the U.S. Department of State who is, and I think this is important, independent from U.S. intelligence agencies. This ombudsperson will ensure that complaints are investigated and addressed, and as an answer from the ombudsperson, the data subject will either receive a confirmation that the relevant U.S. laws have been complied with, or if the laws have been violated, that the situation has been remedied. Finally, EU data protection authorities have the authority to require the EU data exporting company to suspend a transfer to a U.S. company. This concerns, for example, cases in which the transfer to the U.S. company is carried out in violation of EU data protection law, which includes cases where there is a reason to believe that the U.S. company is not complying with the Privacy Shield principles. Todd?
Gina, thank you so much. Jonathan, we've left for you perhaps one of the biggest questions of the day, which is deciding, how do you decide whether the Privacy Shield is right for you? How would you think through this if you were any one of our attendees thinking through, should they pursue or investigate the Privacy Shield?
Thanks, Todd. You're right. This is the key question. Should you look at putting in place a program to adopt the Privacy Shield? Now, we've said that it's a very welcome development. It's a method that you can use to justify systematic transfers of data. It doesn't require consents. It is a relatively simple way of doing that. So they're all key advantages. But the decision whether this is the right one for you is going to be very context specific. And there are a number of factors to take into account. I think the first is to remember that the Privacy Shield is not the only game in town. It's one of a number of methods that you can use to justify your data transfer. And it's possible that a sophisticated international system is going to rely on more than one of these. So the fact that you have the Privacy Shield may not stop the others being relevant, and vice versa. So you may actually need a combination. And Jörg is going to look in a second at the alternatives. But considering the Privacy Shield first, it has some key benefits. In putting it in place, you'll be sending out a strong signal that you're committed to privacy protection. So it has soft benefits. It's a public system. It's a public register. So that may have a key advantage for you. Preparing the way for the Privacy Shield will also require you to assess your personal data use and the transfers you make. That is very important for developing an international privacy compliance program. Again, that's another soft benefit. It may be the right thing for you because you were safe harbor compliant, in which case you just have to do the differential steps to adopt the Privacy Shield. You may find those relatively more easy. And comparing it to the other methods, it has some advantages compared to each of them. Binding corporate rules can be very expensive. They can take you 18 months to put in place. A Privacy Shield compliance program should cost less than that. It should be less intrusive. Standard contractual clauses require you to assess individual transfers of data between different countries, sometimes at a system level. The Privacy Shield does things on a more abstract and general level. That can be more flexible. You can use ad hoc clauses, as we're about to see. However, they require you to make an evaluation of the adequacy of protection at each point. If you have the Privacy Shield, you do not have to do that. And finally, if you rely on an exception like consent, as Undina has mentioned, then you have to check that that is still valid at all points. If you can follow the Privacy Shield, then you do not have that burden. So all of those are key advantages. But you must bear in mind Todd's caveats. It's only available in certain sectors. It is only available and only covers transfers of data to the US. So you may have other global transfer needs that need looking at. It will involve increased US regulatory oversight, and added recourse. And again, that's the quid pro quo of the benefits that it gives. And finally, and I think this could be the key obstacle to overcome, you will have potential renegotiations of your third-party processor contracts, which will be a practical administrative burden you have to go across.
Jonathan, thank you. Jonathan alluded to a number of these other mechanisms. Why don't you kind of explore those with us and tell us what those other mechanisms are that you can choose in lieu of going with Privacy Shield?
Sure. Thanks, Todd. Yes, let's take a closer look at these other data transfer mechanisms. They're still available out there, of course. Some of you on the call have followed, the scrutiny by some of the EU data protection authorities with regard to, for example, the EU model contracts. And most of you may know that are used for intercompany and also external data transfers. They're pre-approved contracts. There's a set text that you cannot change except the annexes or appendices in these model contracts. And there's some filing requirements with the local data protection authorities in some of the member states in Europe, not everywhere, but in some of them. So model contracts are still a useful tool and a valid tool as of today, at least, to cover data transfers outside Europe. Another tool that Jonas mentioned in comparison to the Privacy Shield are binding corporate rules, a very sophisticated, very holistic approach to cover data transfers in an organization, in a global organization. They're mainly used, of course, for intra-company data transfers, so they will not help you in terms of covering data transfers to external providers, for example. There is obviously a lot of work that needs to go into that kind of system. They take a lot of time, up to 16, 18 months. I mean, I agree with Jonathan what he said in terms of timing. It is true that this is more than just a contract, or it's like a code of conduct basically that you implement across the board in the organization that's supplemented by additional other tools to set out rules how the company treats personal information that's flowing between the different entities. So, for example, you need to think about an audit program, a training program for people. So there is much more behind this. And then when you do the submission with the regulators, so there's a lot of work here that needs to go into that. We still have ad hoc agreements available, although I think in practice the use is probably limited. You may want to think about using them for covering certain specific special situations, as these agreements, different from the EU model contracts in most cases, require approval by the local data protection authority, and that by nature, of course, usually gives rise for all kinds of questions. So we enter into some kind of negotiations with the DPA before you even get these ad hoc agreements approved. So again, look at them as probably limited in terms of use in practice. And last but not least, you have a whole list of further derogations, exemptions that you can use under existing law, but also in context of the upcoming EU General Data Protection Regulation. New requirements for consent, as an example here on the slide. As you can see, consent must be explicit. It can be revoked at any time. Sometimes individuals may not even want to give consent. So there are a couple of things here with consent where that makes it difficult in practice to use it. So again, it may be workable in specific cases, but it's not probably a tool to cover the majority of data transfers across an organization or between different countries, or particularly Europe and the United States. So I think the bottom line here is to put the Privacy Shield in context and make sure that you have a holistic view at your data transfers, take into account if you have just shifted from safe harbor to model contracts, what kind of investment you have made, the efforts that went into that. Is it worth changing mechanisms going forward? How does the Shield fit in? Is it worth looking at your data flows and the assessment and potential risk assessment, particularly to use the Shield in addition to other tools that you may still want to apply to cover data transfers in other regions outside the U.S. So they can work in parallel, right? They're not that one transfer mechanism trumps the other one. It is really about finding out data flows and mapping them properly, understand where the risks are, and then choosing the right tools. And I think there are still a number of them available as of today.
Jorg, thank you so very much. Let's talk about now, if after all this you want to go forward and go with the Privacy Shield, let's talk about the steps to self-certification. Now, a bit of warning that what we're going to talk about in the next few slides is really just a high-level overview of some of the requirements. there is much more to it than what we articulate here in these slides. There are exceptions and exceptions to exceptions, so this requires a little bit more effort than what we describe. But what we want to provide here is just give you a sense of what's involved in this process. Now, the first step is going to be identifying eligibility. I mentioned this previously where we're talking about, are you under the jurisdiction currently of the DOT or the FTC? If you're not, you cannot use the Privacy Shield. Now, as I mentioned before, we are expecting other agencies to come forward, and that will then broaden the scope of companies that can use Privacy Shield. But at the moment, you have to be under the jurisdiction of the DOT or the FTC. The second step would be to go about an effort to really understand your data flows. What kind of data are you transferring to the United States? Where is it coming from? Who is the information about? What kind of data is it? Is the data sensitive data or not? All of these carry additional requirements and obligations under the Privacy Shield and also under local European law that you have to be mindful of and be on top of as you identify and work through your certification process. Then you're going to want to conduct some form of an internal compliance assessment. We are expecting, and there's some mention of this previously, that the FTC and DOT are going to be much more aggressive this time around in enforcing Privacy Shield. There was mentioned by the FTC that they're going to send out questionnaires. They've more than doubled their staff. They are really gearing up to enforce this thing, and they're very serious about it. So you have to make sure that you do some kind of an internal compliance assessment to look into this. And just as a further example of that, we know that the FTC has been very aggressive when it comes to data security. And we know that one of the principles deals with the security of the data, and now with the FTC policing security, there's a whole bunch of jurisprudence already on the books by the by the FTC and their various enforcement actions, and that may very well carry over here. So, in front of your compliance assessments, understanding where you have gaps ahead of time will save you a lot of headaches later on. And then you're going to want to develop your Privacy Shield compliant privacy policy statement. Jennifer went through that a little bit, but that's going to be a very involved process because it requires much more detail than it previously did under Safe Harbor. Then you're also going to want to adopt some internal controls and policies to make sure that once you've done your gap assessment, you close those gaps. For example, you're going to want to make sure you have means for your European people to access their data and to potentially opt out where they are permitted to do so. And then, of course, you want to examine your data retention policies. Dina, why don't you talk about the recourse mechanism aspect of self-certification?
Thank you, Todd. Let's take a look at the further steps to be taken for self-certification. As mentioned earlier, a company must provide for an independent recourse mechanism in place prior to the self-certification process. The company can either designate an independent dispute resolution body, like, for example, the Council of Better Business Bureaus or trustee or the like. Alternatively, the company may voluntarily choose to cooperate and comply with the EU data protection authorities with respect to all of its data. Again, similar to the situation under Safe Harbor, if a company's self-certification is intended to cover HR data in the employment context, then the company must submit to the oversight of the EU data protection authorities with respect to such data. As Jörg mentioned, data security is an important principle under Privacy Shield. So a company should make sure that it has implemented the required specific data security measures. Such measures should take into account the relevant risk and the nature of the personal data transferred in order to prevent their loss, misuse, unauthorized access, deletion, or disclosure. In order to verify a company's compliance with the Privacy Shield requirements, the company has to put in place a verification mechanism. Compliance must be verified actually on an annual basis, either by conducting a self-assessment or by relying on a third-party assessment program. As mentioned earlier, onward transfer agreements are going to be an important point. Third-party contracts, be it either with third-party controllers or third-party processors, will need to be reviewed if they comply with the Privacy Shield's onward transfer principle requirements, and often there will be a need for renegotiation of such contracts. A company should also identify a suitable contact person for handling all these issues arising under the Privacy Shield. For example, handling complaints. And in this context, please keep in mind that the company must respond to an individual within 45 days of receiving her or his complaint. The contact person can either be the corporate officer that is certifying the company's compliance with the Privacy Shield framework, or another official within the company organization, for example, the chief privacy officer. Finally, documentation of a company's compliance activities is key. Given that companies certifying under the Privacy Shield will be subject to heightened scrutiny by U.S. regulators, as Todd mentioned before, maintaining evidence of compliance with the Privacy Shield is really critical. Todd?
Thank you, Undina. Just real quick, I'm going to walk through very briefly some of the steps that you actually have to go through to actually file self-certification. More of this is summarized in Supplemental Principle 6, but just real quickly here, among the things that you have to provide when you file your certification, you have to provide a description of your organization's activities with respect to personal data. And this is where that data flow assessment that I mentioned previously really comes into play and helping you understand so that you can then describe it as a part of your filing. You have to provide the website where your privacy statement is published, or in the case of HR data, the HR privacy policy that you make over to your employees. You have to provide contact information, such as contacts for complaints, access requests, and issues as a part of those recourse mechanisms that Undina was describing. You have to provide the name of the privacy program in which you're a member or participate. You have to describe the independent recourse mechanism that you're making available to data subjects. And then afterwards, some of the other things you want to do, you definitely want to update your assessment report and maintain that. And that's going to be something that we actively address because they are expecting companies to be compliant. This is not a one-time thing where you make your filing, you have controls, you're done. They are expecting companies to really regularly review this and update and improve their compliance on an ongoing basis. Just a couple other things. As a part of your filing, you have to have a signature of a corporate officer. You have to pay a certification fee. We're not expecting that to be that much. I think the numbers we've been provided will be as low as $250 if you're a company with annual revenue of less than $5 million, or if you're a company above $5 billion, it's $3,200, $3,250 actually. And then if you're anywhere in between, it's in that range. So less than $3,250 or above $250, somewhere above there. And then just real quickly, last, Privacy Shield training. As a part of that ongoing process to make sure you maintain your compliance with Privacy Shield, you've got to train your employees. You've got to train them how to address investigation or complaints when they come on. How do they handle personal data? If there are new types of data, there needs to be someone who is responsible for managing this program and then updating their certifications as necessary. Jonathan, why don't you now talk about looking ahead? What should we expect in the near future? Any challenges, or what do you see?
Thanks, Todd. And I mean, clearly, the Privacy Shield has been born out of challenges to the data protection and transfer regime, and the seas aren't smooth in this area. And I think there are going to be more changes ahead. The Privacy Shield was brought in to replace the Safe Harbor, which was struck down after a challenge that made a number of points. While the Privacy Shield has changed the rules that apply to address those issues, it's been a question of degree. And it's perfectly possible to use the same arguments to say the protections that are given by the Privacy Shield are still not enough, or the recourse is still not strong enough, or probably most politically sensitively, the potential access by US authorities is still too great. So I think we think that some form of legal challenge to the Privacy Shield is fairly likely. Now, there's not much we can do about that, and I think it's still important to make your best assessment of the method that's right for your business. But equally, you need to keep an eye on how things are going and how it's being received, both by the courts and by the EU authorities. Challenges are not going to be restricted to the Privacy Shield. There are ongoing challenges to some of the other data transfer mechanisms. At the moment, there is a challenge before the Irish courts to do with the standard contractual clauses, using similar arguments that were made against the safe harbour. So there isn't a right answer for what is the safe method of future-proofing these. I think it's make the best choice now and be alert and sort of proactively look out for the changes that might come. Jorg, I know there's been something from the Article 29 Working Party on this.
Jorg, you're on mute.
Yes, thank you, Jonathan. As Ondina pointed out earlier at our webinar today, there was a very recent development. The Alternative Working Party came out with an additional statement. So after the final text was adopted, and they expressed that they still have concerns about the shield in the way it was adopted, which of course is something to keep in mind looking ahead. I mean, obviously I don't have a crystal ball here, but I can tell you when you look at these that statement, basically the concerns are twofold. One is concerning commercial aspects. Just to give you a couple of examples, the European authorities think there's still a lack of specific rules on automated decision making and the general right to object to certain data processing. At the same time, they also still criticize access by public authorities to data transferred to the United States under the shield. And they're kind of looking for a bit more stricter guarantees concerning the independence and specifically the powers of the ombudsman and the whole mechanism around it. So you can see there's still these kind of uncertainties in terms of the viewpoints of the authorities. Nevertheless, of course, we have a legally valid text of the shields that can be relied on. So I think we will know more about how robust the whole system is and the efficiency when the European DPAs will look at it in a year from now, and they will probably take a very close look to see how it works in practice and where the deficiency may still lie.
Well, thank you, Jorg. Transition to some questions then. Jennifer, you want to take on?
Thanks, Todd. Thanks, Jorg. So now we'll just take an opportunity to, filter and address some of the questions that have been posed by the audience. One question we continue to get is, Jonathan, really, how will Brexit affect the privacy shield? Can you touch on that?
Thanks, Jennifer. I mean, clearly Brexit and the UK leaving the European Union is a huge topic. And one thing we don't know at the moment is what's going to happen. Clearly this is going to take time. Most people think that the act of leaving will take at least 2 years, maybe more. During that period, existing data protection rules apply, so the Privacy Shield remains relevant in that period. But once the UK has left, it depends on its future relationship with the European Union. If the UK joins the European Economic Area, which is the so-called Norwegian model, then the Privacy Shield will still apply because the UK will be part of the sort of common European data zone. If the UK decides to adopt what's known as the Swiss model and have a series of bilateral relations negotiated with Europe, then it needs to do something about data transfers, and it's very likely there will be some form of bilateral agreement, maybe in the form of a UK version of the Privacy Shield. But again, we can't say at the moment. And finally, if the UK decides to try and declare digital independence and go its own way, it will then be treated in the same way as the US. So transfers in Europe will either need it to be an adequately protective regime, which is likely to mean adopting very similar rules to the European Union, or it will have to get its businesses to put in place one of the methods of transfer that Jorg has outlined, standard clauses, binding corporate rules, or something like the Privacy Shield. So whatever we do for Brexit, this is likely to remain very relevant.
Thank you, Jonathan. One question we've gotten from the audience is, can a corporate parent certify for itself or for its subsidiaries on a single certification application, or must each member of a controlled group certify it separately? Todd, do you think you can address this question?
Yeah, it's a really simple answer. The answer is yes. Yes, you can identify multiple entities as a part of your single filing. In fact, as a part of the questionnaire it asks, list all entities and subsidiaries of your organization covered by this self-certification. So yes, you can.
Great. Thanks, Todd. Jonathan, one thing I wanted to ask then, I guess, is it a good idea then, taking into account everything we've talked about on during today's presentation, is it a good idea for companies to self-certify compliance during this grace period that Todd had touched on earlier, namely, for the next 2 months, and then allowing themselves, I guess, the 9-month period, the period by which to get the Onward transfers in order? Does that make is that a good idea for companies to consider?
I think it is, as long as you've taken the time to make that assessment that the Privacy Shield is for you. I certainly think the key thing is to make that choice first. But then just to flesh it out a bit, the advantage in making the certification within 2 months is you get a 9-month grace period to put your relationships with your third-party data processors in order. And we think that's going to be one of the more difficult steps for companies to comply with, because it will require a negotiation with however many third-party processors you have. And this is a new thing for both sides. So there probably won't be the contractual models out there that people can readily go for. There will have to be some genuine debate. So there is an advantage. If the Privacy Shield is for you and you can take advantage of this 2-month period, then that is great. But bear in mind, for a large organization, 9 months to do these negotiations may not be enough, in which case you probably wouldn't want to expose yourself to the increased eye of the regulator. You might want to consider something else until you were truly ready to go for this.
Thanks, Jonathan. That's a great point. And it really sort of dovetails into, we know a lot of corporations may have transitioned over to other data transfer mechanisms like the model clauses or after the invalidation of Safe Harbor. And now the companies are maybe considering the Privacy Shield. George, maybe you can discuss, or a question we've gotten is, what will become of, model clauses, for example, if a company had executed or even registered with data protection authorities if they're considering to now self-certify compliance with the Privacy Shield?
Well, thanks, Jennifer. That's a very good question, of course, to look at that. I mean, it's not going to be enough just to say, okay, now we have the shield in place and we follow, all the certification requirements that Todd outlined earlier. I think when you look at your clauses that you have in place and they were executed and maybe even registered, right, in certain countries with the local data protection authorities, so you have to take a look at this from all these different angles. You clearly have to, of course, if you decide to do so, terminate the model contracts for transfers. At the same time, you have to also look how you deal with the pending situation in front of the authorities where you have done certain registrations, notifications, and where you may have submitted the model contract clauses. So you have to talk and submit, of course, a clarification and in some member states, and then indicate that your data transfer mechanism has changed, right? And so you have to notify the authorities about that, and in the different countries to make sure, what you have, what's on file with the authorities, consistent with the transfer mechanism using in practice. So there are a number of steps here on the administrative level to follow. Nothing really major, but of course it needs to be executed to make sure the organization is relying on one data transfer mechanism only and doesn't get in conflict with having 2 of them still in place.
Thanks, George. Another question that we've gotten, we only have a minute here to line up. Undina, perhaps can you address this as a more of a logistic question? But when you self-certify compliance with the Privacy Shield, when do those obligations come into place? Is it right when you sign up? In other words, when you certify compliance with the Privacy Shield, are you obligated to comply with the provisions of the privacy principles from that moment? And perhaps we've lost Undina on the line. Well, we may have lost one of our speakers. Jörg or Jonathan, maybe you can touch on for the audience. When you do certify compliance, right when you submit the application, are you obligated to comply with the principles at the time you submit your application.
Make sure you're unmuted if you answer.
Absolutely. I mean, you're certifying, so you need to be compliant at the point you certify. So you can't certify prospectively, which I think goes to my point about considering the grace periods and how long you need to do this. I mean, Todd, I don't know if you have any practical suggestion about the time that it might take people to actually get through this process.
Well, I think the 2 months, it depends on the organization and the nature of your data transfers, of course, and just how big of a company and what you're trying to certify to. And that leads to points of it may be worthwhile to bifurcate your filings where you're filing for certain types of data and use some other kind of transfer mechanism to facilitate the others. So you really need to think of how much data, what type of data, and can you get ready. And that's, of course, if you tell yourself of the 2-month process or some other period of time. I would also note that when you're using this, the Privacy Shield is a different question, and I believe that's from the date that you go online is identified on the website as being certified to Privacy Shield.
Thanks, Todd. And then I know we're wrapping up the hour here. But one last question that we'll have with audiences is, what will happen with respect to self-certification process available to companies under the Safe Harbor framework? And Dina, will you be available? Can you address that question quickly in the time remaining?
Yes, of course. I think it's important for us to note that since Safe Harbor has been invalidated in October last year, it can no longer be used as a valid transfer mechanism to the U.S. And also, as Todd already mentioned, since of yesterday, the DOC has stopped accepting new submissions for self-certification to the Safe Harbor framework. Also, at the end of October, the DOC will stop accepting any recertifications. However, the DOC will maintain the list of participants in the Safe Harbor program, and it has been pointed out specifically also on the website, on the Safe Harbor website of the DOC, that the commitment to adhere to the Safe Harbor principles is not time limited. So this means a company participating on the Safe Harbor must continue to apply its principles to the data that it received previously under the Safe Harbor.
Thank you, Andina. And with that, I think we have reached the end of the hour. Our last slide here provides the contact information. We encourage the audience, if you have any specific questions, so please reach out to any of us on the line with our Jones Day team. We'll be happy to answer any of your questions with regard to the Privacy Shield and other data mechanisms you may be considering to transfer personal data to the United States. Thank you again for your time, and with that, I'll leave it with Monica to close us out.
Thank you. Thanks again to our presenters, and a special thanks to everyone in the audience. If you meet all the criteria to receive your CLE credit, you will receive an email within 24 hours. If you do not receive the email, please contact Beacon Live. Goodbye.